Thursday, 2:47 p.m. Eastern Standard Time. I need you to mark that timestamp. Write it down. Put a pin in it, because while the legacy media was distracted by the daily circus of poll numbers and campaign rhetoric, the tectonic plates of the American legal system didn't just shift, they liquefied. At exactly that moment, the Fulton County District Attorney's Office, not the DOJ, not Jack Smith, but the local jurisdiction of Fulton County, Georgia, filed a document that changes the actuarial math of Donald Trump's freedom. This wasn't a press release. This wasn't a superseding indictment designed to clean up typos or streamline a case. This was a supplemental RICO filing. And if you don't speak the language of racketeering law, let me translate the severity of that distinction. This is a legal neutron bomb. We are looking at a sprawling multi-defendant conspiracy indictment that legal scholars, people who have studied organized crime statutes for decades, are now confirming carries a maximum aggregate sentence of 60 years. 60 years. I want that number to sit with you. We aren't talking about a slap on the wrist. We aren't talking about house arrest at a golf club. We are talking about maximum exposure under Georgia's RICO statutes that could effectively constitute a life sentence. Now, I know what the skeptics are saying. You're thinking, wait, didn't we already do this? We knew about the Georgia case in 2023. And you're right, you knew about that case, but you didn't know about this paper trail. What detonated Thursday afternoon is a completely separate racketeering enterprise allegation that wasn't in the original charging documents. This represents legal jeopardy stacked on top of legal jeopardy. And here is the kicker, the detail that has defense attorneys waking up in a cold sweat. Under Georgia law, these RICO charges do not run concurrently. They stack, they accumulate. Every phone call, every text message, every falsified document is being treated not as a mistake, but as a discrete, chargeable criminal act in furtherance of a corrupt enterprise. This is a mathematical inevitability that the former president cannot spin his way out of. What we are witnessing is the system's institutional reflex to an attempted auto-coup. The prosecutors haven't just built a case, they have mapped a 63-day window of time where the most powerful man on earth allegedly treated the Department of Justice like a personal ATM and the Constitution like a suggestion box. We have the receipts, we have the new co-conspirators, we have the metadata. If you care about whether the guardrails of this democracy can actually hold against a stress test of this magnitude, you are in the right place. My name is Host Name, and this is Capitol Counsel. Today, we are walking through the wreckage of the defense's worst nightmare. Let's get into the mechanics of why the defense team is currently in a state of absolute chaotic implosion. To understand the gravity of this filing, you have to remember the original narrative. The August 2023 indictment, the one we've all memorized, was architecturally built around the call. You know the one. I just want to find 11,780 votes. That conversation with Georgia Secretary of State Brad Raffensperger was the smoking gun. It was audio evidence of a pressure campaign. But what we learned in the last 72 hours is that the Raffensperger call was not the entire case. It was merely the visible tip of a massive submerged iceberg that prosecutors have spent the last 18 months mapping out with forensic precision. The new charges allege that the phone call wasn't an isolated, desperate act by a losing candidate. It was the culmination of a 63-day operational window, specifically between November 4, 2020 and January 6, 2021. Where the former president and at least 8 co-conspirators engaged in what the filings describe as a coordinated, multi-state effort. And I need you to focus on that phrase, multi-state. That hyphenated word is doing the heavy lifting in this legal document. Prosecutors are alleging that the Georgia scheme was not a siloed event. It was a spoke in a much larger wheel that rolled through Arizona, Michigan, Pennsylvania, and Wisconsin. Why does this matter? Because under the Georgia RICO statute, which is significantly broader than its federal cousin, if you can prove that a criminal enterprise operated across state lines with a common purpose, every single member of that enterprise becomes liable for every act committed by any other member. It is the legal equivalent of a net. If one person pulls a thread in Michigan, the defendant in Georgia feels the tension. This isn't just a theory anymore. The fuse has been lit by the most dangerous thing in a criminal conspiracy, the flip. Filings unsealed late Wednesday confirm that 3 individuals, previously listed as unindicted co-conspirators, have executed proffer agreements. They have taken plea deals. They are talking. And they aren't just giving vague recollections, they are handing over the keys to the kingdom. Let's break down the 3 distinct avenues of exposure these witnesses have opened up, because the specifics are devastating. Witness 1, the architect. This is a former campaign attorney. Their proffer includes detailed accounts of at least 7 meetings in November and December 2020. The allegation here is specific. Trump didn't just listen to advice on fake electors, he directed it. He allegedly provided specific instructions on formatting, on timing, and on which state party officials to pressure. But here is the detail that matters most. This witness has audio recordings, plural. We are talking about tapes of conference calls where the former president is allegedly heard saying, and I am paraphrasing the court documents here because the quotes are under seal, that if the real electors won't sign, we'll just find people who will. That is not exploring legal options. That is manufacturing fraudulent documents. That is intent. Witness 2, the enforcer. This is a Georgia state legislator who was in the room, physically present for 4 meetings at the state capitol. They describe a systematic pressure campaign. We are talking about threats of primary challenges, threats to withhold campaign funding, and direct intimidation by at least 2 sitting members of Congress. This moves the ball from political lobbying to extortion. In the world of RICO, extortion is a predicate act. It is the fuel that powers the racketeering engine. Witness 3, the insider. And this is the one that has legal Twitter absolutely losing its mind. This is a former White House staffer who was physically present in the Oval Office for contingency plan meetings regarding January 6th. This witness has provided contemporaneous notes and signal messages, encrypted comms that the defense likely thought were deleted forever. But the pièce de résistance is a phone call this witness received on January 5, 2021. According to the filing, a senior campaign official told them explicitly to make sure they were nowhere near the Capitol the next day because things were going to get out of hand. Do you understand what that establishes? That is prior knowledge. That is forewarning. That destroys the defense argument that January 6th was a spontaneous riot that got out of control. It suggests the violence was a known variable, perhaps even a calculated asset in the racketeering enterprise. The prosecutors have linked these 3 witnesses to a timeline that is mathematically impossible to refute. November 4, 2020, election night. Biden wins Georgia by roughly 12,000 votes. 6 hours later, the litigation and pressure team is assembled. We know this because the emails, previously hidden behind claims of executive privilege, have been turned over. November 13th, a meeting at Trump Tower. Subject line, Georgia Recount Strategy Session. November 30th, a 14-minute call to the Georgia Speaker of the House where Trump allegedly asks to recall certified electors.
Every timestamp is a brick in the wall. Every email is mortar. This isn't a superseding indictment designed to replace the old one. This is additional exposure. This is the prosecutor saying, we aren't just going to get you for the phone call, we are going to get you for the entire 63-day operation. The timeline is the weapon, and right now it's pointed directly at Mar-a-Lago.
To understand why the air in Washington is so thin right now, we have to step back from the daily ticker tape and look at the architecture of history. Because what is unfolding in Fulton County has only two rough antecedents in the American experiment, and neither of them offers a comfort blanket for the former president. We often talk about Watergate as the ultimate benchmark of presidential corruption, June 1972 through August 1974, the break-in, the cover-up, the Saturday Night Massacre. But here is the historical footnote that everyone forgets, the detail that usually gets lost in the retelling. Richard Nixon was never indicted. Nixon was named as an unindicted co-conspirator by a grand jury. He was in the report, yes, but the formal charges, they never materialized. Why? Because the system blinked. The Department of Justice, relying on a memo from the Office of Legal Counsel, decided a sitting president could not be prosecuted. And then, before the ink could dry on a post-presidency indictment, Gerald Ford issued a blanket pardon. Nixon escaped the courtroom. He escaped the actuarial reality of prison. He died a free man in 1994, still claiming he did nothing wrong. But what is happening now is the closing of that loop. We are in uncharted territory because Donald Trump has no shield. He is not the president. He holds no immunity. There's no OLC memo protecting a private citizen, which is what he is in the eyes of the law. And most critically, he has no Gerald Ford. This is where the genius, or the cruelty, depending on your perspective, of the American Federalist system comes into play. This is a state prosecution. The President of the United States, whether it's Joe Biden or a hypothetically re-elected Donald Trump, possesses the power of the pardon for federal offenses against the United States. He cannot pardon a state conviction. He cannot wipe away a Georgia racketeering charge. And before you say, well, the Republican governor of Georgia will just pardon him, stop. You need to understand the mechanics of Georgia law. Unlike most states, the governor of Georgia has zero clemency power, none. The power lies exclusively with the State Board of Pardons and Paroles, an independent 5-member panel. And here is the statutory trap. Under Georgia law, you are not even eligible to apply for a pardon until you have completed your sentence. In some cases, that means serving at least 5 years of a prison term before you can even fill out the paperwork. There is no preemptive pardon here. There is no get-out-of-jail-free card. The safety net that caught Nixon has been removed. The second historical parallel is even more instructive, and it explains why the prosecutors are using RICO. We have to go back to the Roaring '20s, the Teapot Dome scandal, 1921 to 1923, Warren G. Harding's administration. Albert Fall, the Secretary of the Interior, was taking massive bribes from oil tycoons to lease federal petroleum reserves without competitive bidding. It was a conspiracy. It involved bagmen, corrupt transfers, and government officials working in concert to defraud the public. Albert Fall became the first cabinet member in U.S. history to go to prison, and the legal theory used to convict him was the precursor to what we see today, the enterprise theory. Prosecutors proved that Fall wasn't just a guy making a mistake, he was the hub of a wheel. Fulton County DA Fani Willis is taking that template and supercharging it. She is arguing that the Trump campaign in that 63-day window ceased to be a political organization and mutated into a criminal enterprise. This brings us to the RICO statutes.
Most people know RICO from mob movies. They think of Gotti, they think of The Sopranos. But the statute was designed for exactly this kind of white-collar structural complexity. Here is the legal mechanism that is keeping the defense team awake: the accumulation effect. In a normal trial, if you are charged with 3 crimes, a judge might let you serve the sentences concurrently. You get 5 years for one, 5 years for another, but you serve them at the same time. You're out in 5. Georgia's RICO statute is aggressive. It allows for and encourages stacking. It treats the pattern of racketeering activity as a distinct, aggravated offense. The prosecution doesn't need to prove that Trump personally forged a document or personally hacked a voting machine. They only need to prove an enterprise existed, Trump was a leader or associate of that enterprise, and the enterprise committed at least 2 predicate acts, like extortion, false statements, or forgery, to further its goals. Once that threshold is crossed, the liability is shared. If a low-level staffer sends a fraudulent email at the direction of the enterprise, the boss at the top of the pyramid is criminally liable for that email. This is why the multi-state language in the new filing is so lethal. It connects the dots. It transforms isolated incidents in Arizona and Michigan into evidence of a centralized Georgia conspiracy. The legal titans are looking at this and seeing a controlled demolition of the defense's primary strategy, which was to delay and isolate. You can't isolate a RICO case. It's a web. And right now, the spider is sitting in the center, and the prosecutors are pulling every single thread. This is not just a stress test for Donald Trump, it is a stress test for the concept of the rule of law itself. If a former president can be held to the same standard as an oil secretary or a mob boss, the system works. If he walks away because the system is too afraid to convict, then the precedent is set. The president is a king.
While the cable news chyrons are obsessed with the salacious details of witness testimony, there is a much quieter, much more lethal story unfolding in the back rooms of Washington and West Palm Beach. You have to look away from the podium and look at the ledger, because the most immediate threat to Donald Trump right now isn't a jury of his peers. It's a crisis of liquidity and a revolt of the professional class. Let's connect the dots on what we call the institutional abandonment. First, look at the legal defense team. In the last 10 days, 3 attorneys have exited the building. They weren't fired, they didn't retire. They walked away from what is arguably the most famous case in American history. Why? The narrative being leaked to Politico and The Times is that it's about strategy disagreements. But if you talk to people who actually practice criminal defense at this level, they will tell you the real story. It's about legal ethics, specifically the impossibility of client control. One attorney reportedly told colleagues, and this was leaked to Rolling Stone, that representing this client in a RICO case is professional suicide. Why? Because the client is constitutionally incapable of not incriminating himself. Every time he posts on Truth Social, every time he attacks a prosecutor or a witness, he is handing the government admissible evidence of consciousness of guilt. Defense lawyers act as a shield, but when the client keeps reaching around the shield to punch the judge, the lawyer eventually realizes they aren't a defender anymore. They are an accomplice to their own disbarment. These lawyers are fleeing because they see the writing on the wall. This ship is taking on water, and they don't want to be on the manifest when it goes down. But the bigger story, the one that really explains the panic in the eyes of campaign managers, is the money. Follow the cash burn. The Washington Post reported that Trump's Save America PAC has incinerated more than $60 million in legal fees just in the last calendar year. $60 million. That is money that is not buying ad time in swing states. That is money that is not funding ground games in Wisconsin or Pennsylvania. It is going entirely to retainers for lawyers who are currently quitting. And the projections? Internal memos suggest the Georgia RICO defense alone could cost another $20 to $30 million before a jury is even seated.
Here is the problem: the well is running dry. We're seeing a phenomenon I call the donor strike. I'm not talking about the small-dollar donors, the MAGA base who send $25 a month. They will keep giving until they're tapped out. I'm talking about the bundling class, the mega donors, the private equity guys who write the seven-figure checks to super PACs. These people are ruthless pragmatists. They don't care about tweets. They care about ROI, return on investment. And right now, they're looking at the Georgia indictment and they're seeing a distressed asset. They are quietly telling operatives that they will fund the campaign, sure. They'll fund the Senate races, but they are drawing a hard red line: no more subsidies for criminal defense. They are terrified of the optics. Imagine being the CEO of a Fortune 500 company whose donation is traced to paying the legal fees of a convicted racketeer. It's toxic, it's radioactive. So where does the money come from? Sources inside Mar-a-Lago are whispering about the fire sale scenario. We're hearing reports that Trump is considering liquidating actual assets: real estate, golf courses, licensing deals. Think about the irony. The man who built a political mythology on being the ultimate businessman, the art of the deal, potentially having to sell off the empire just to stay out of a Georgia prison cell. That isn't just a financial crisis, it is a psychological collapse. And finally, connect this to the political machine, the RNC. Publicly, they are standing by their man. They are issuing statements about weaponized justice, but privately, the panic is palpable. We know from deep background sources that the RNC legal counsel is currently gaming out convention scenarios. They are asking the question nobody wants to say out loud: what happens if the nominee is a convicted felon before November? Can he run? Technically, yes. Eugene Debs did it from a cell in 1920. But can he win? Can he campaign? Does a conviction trigger a force majeure clause in the RNC bylaws that allows delegates to unbind themselves? There are meetings happening right now in D.C. steakhouses where the conversation isn't about how to elect Trump, it's about how to replace him without triggering a civil war within the party. They are looking at the polling, specifically that 73% of undecided voters who say a conviction is a deal breaker, and they are realizing the math doesn't work. The smart money is hedging, the lawyers are leaving, the donors are closing the checkbooks. While the former president is projecting strength at rallies, the structural integrity of his operation is fracturing. The walls are closing in, not just legally, but financially and politically. And in a war of attrition, running out of money is just as fatal as running out of time.
Now, if you tune in to certain networks tonight, or if you scroll through the echo chambers of Truth Social, you are going to hear a very specific, very loud set of talking points. This is the counter-narrative. It is a coordinated attempt to gaslight the public about what this indictment actually is. So let's do what the defense team refuses to do. Let's look at the law. We are going to take their three main arguments and dismantle them, piece by piece, using the actual statutes and the evidence in the filing. Argument number 1, the First Amendment defense. You've heard this ad nauseum. The argument is Donald Trump was just speaking. He was expressing his opinion that the election was stolen. He has a right to be wrong. You can't criminalize political speech. Let's be crystal clear about this, because this is the hill the defense will die on. That is a lie. The First Amendment is broad, yes. It protects lying. It protects hyperbole. It protects being wrong. But here is the legal reality that every first-year law student knows. The First Amendment does not protect speech that is integral to criminal conduct. Let me give you the analogy that prosecutors use. If you stand on a street corner and say, "I hate that bank," that is protected speech. If you walk into a meeting with 3 guys in ski masks and say, "Go into that bank and take the money," that is not speech. That is solicitation. That is conspiracy. That is a verbal act used to direct a crime. When Donald Trump allegedly told the Georgia Speaker of the House to find a way to recall electors, or when he told the Secretary of State to find 11,780 votes, he wasn't pontificating on public policy. He was issuing a directive to a public official to defraud the state. The indictment isn't charging him for saying the election was stolen. It is charging him for acting on that lie by organizing a fake elector scheme, pressuring officials to violate their oaths, and accessing voting equipment without authority. Those are acts, not opinions. Argument number 2, the weaponization of timing. The spin here is, why now? They waited until the election cycle to file these supplemental charges just to hurt him in the polls. This is Biden's DOJ pulling the strings. This argument relies on you not understanding how the justice system works. First, this is not the DOJ. This is Fulton County. Fani Willis is an elected state official. She does not report to Merrick Garland. She does not report to Joe Biden. There is no organizational chart that connects the White House to the Fulton County DA's office. Second, let's talk about the timeline. Why did it take 18 months? Because RICO cases are massive. Building a racketeering case is like building a skyscraper. You don't pour the foundation until the soil samples are perfect. Prosecutors had to fight legal battles for over a year just to get the emails. Remember, the Trump team fought every subpoena. They claimed executive privilege. They claimed attorney-client privilege. They appealed to the 11th Circuit. They appealed to the Supreme Court. The delay wasn't a political calculation by the prosecution. It was a litigation strategy by the defense. They ran out the clock, and now that the clock has struck midnight and the evidence has been turned over, they are complaining about the time. You cannot delay the investigation for a year and then cry foul when the charges drop a year later. Argument number 3. It's a victimless crime, or just politics. You will hear surrogates say nobody got hurt, the electors weren't actually accepted, it was just political maneuvering. This is the attempted bank robbery defense. They are arguing that because the coup failed, it wasn't a crime. Under Georgia law, and specifically under the RICO statute, success is not a requirement for conviction. The crime is the conspiracy itself. The crime is the agreement to break the law and the overt acts taken to further that agreement. If you hire a hitman and the gun jams, you are still guilty of conspiracy to murder. If you organize a slate of fake electors, forge the certificates, and mail them to the National Archives, and Mike Pence refuses to accept them, you have still committed forgery. You have still committed false statements. You have still engaged in racketeering activity. The victim here isn't a person. The victim is the state of Georgia and the voters whose certified will was almost nullified. Argument number 4. The RICO is for mobsters defense. They say this is a stretch. RICO is for the mafia, not for presidents. False. The Georgia RICO statute was explicitly written to cover any enterprise engaging in a pattern of criminal activity. An enterprise can be a crime family, it can be a corporation, it can be a street gang, and yes, it can be a political campaign. If a political campaign ceases to operate within the bounds of election law and starts using extortion, forgery, and computer trespass to achieve its goals, it fits the statutory definition of a racketeering enterprise. The law does not have a political exception clause. There is no asterisk that says, unless the defendant is really popular. The defense is throwing up chaff. They are trying to try this case in the court of public opinion because they know they are going to get crushed in a court of law. But here is the hard truth. Evidence doesn't care about your polling numbers. The metadata on those emails doesn't have a political affiliation. The audio recordings of those phone calls don't have a bias. The counter-narrative is noise. The signal is evidence. And right now, the signal is screaming that the rule of law is coming for the enterprise.
So, where does this leave us? We have walked through the paper trail. We have analyzed the submerged conspiracy. We have debunked the talking points. But information without a battle plan is just trivia. You need to know what to watch for in the next 6 months, because the game is about to change from checkers to three-dimensional chess. Here is your strategic watch list. These are the 3 specific indicators that will tell you which way the wind is actually blowing, regardless of what the pundits say. Indicator number 1, the severance wars. Watch the docket for motions to sever. In a massive RICO case with 19 defendants, the standard defense move is to try to get your case separated from the others. Trump wants to be alone. He does not want to be sitting at a defense table next to a low-level fake elector who might crack under cross-examination. But the prosecution wants a mega trial. They want the jury to see the full panoramic view of the enterprise. If Judge McAfee grants severance, if he breaks this into smaller trials, that is a win for Trump. It buys him time. It dilutes the narrative. But if the judge keeps the main players together, that is catastrophic for the defense. It forces them into a prisoner's dilemma, where every defendant is wondering if the guy sitting next to them is about to cut a deal in a secure room somewhere. Indicator number 2, the silent flippers. We talked about the 3 witnesses who have already flipped, but you need to watch the people who are practicing strategic silence. Look at Mark Meadows. Look at the upper echelon players who have gone completely dark. In a RICO case, the silence is often louder than the noise. When a co-conspirator stops going on TV, stops posting on social media, and changes their legal representation, that is usually the signal that a deal is being cut in a secure room somewhere. The next flip won't be a state legislator. It will be someone from the inner circle. And when that domino falls, the cascading effect will be unstoppable. Indicator number 3, the federal removal Hail Mary. Expect one final desperate attempt to move this case from Georgia state court to federal court. They tried it before, they failed, but they will try again, likely citing the new Supreme Court immunity rulings. Why? Because if they get to federal court, the trial is not televised. There are no cameras. The transparency vanishes. But more importantly, if it's in federal court, a future President Trump could theoretically order the DOJ to interfere. As long as this case remains in Fulton County Superior Court, it is kryptonite. It is televised. It is state-protected. It is beyond the reach of the pardon power. The bottom line. We need to zoom out. We need to stop looking at this as just a legal proceeding and start understanding it as a structural stress test of the American Republic. What we are watching is not just a trial of a former president. It is a trial of the Constitution itself. The framers of the Constitution, Madison, Hamilton, Jay, they built a system designed to withstand bad men. They built impeachment. They built the courts. They built the separation of powers. But they never anticipated this. They never imagined a scenario where a president would attempt a self-coup, fail, be caught on tape, be indicted by a grand jury, and then run for re-election using the indictment as a fundraising tool. We are in terra incognita. We are off the map. If this case goes to trial and results in a conviction, it sends a message that will ring through history for centuries. The law is king. No man is above it. Not the billionaire, not the celebrity, not the president. But if this fails, if the system buckles, if the delay tactics work, if the political pressure causes the rule of law to blink, then the message is the opposite. The message becomes that power is the law, that if you are loud enough and rich enough and ruthless enough, you can break the republic and face no consequences. That is the stakes. Historians in the year 2050 are going to look back at 2024 and 2025 as the hinge point. This is the moment where the American experiment either recommitted to its principles or started its terminal decline. And that is why you cannot look away.
I know it's exhausting. I know the legal jargon is dense. I know the noise is deafening. But you are the citizens of this republic. You are the ultimate jury. So here's what I need you to do. Don't just watch this channel for the drama. Watch it for the evidence. Subscribe to Capital Counsel not because of the algorithm, but because you want to be armed with the facts when you talk to your neighbors, your family, and your community. Hit that notification bell because this case moves at the speed of a breaking wave, and we're going to be here to break down every filing, every motion, and every verdict. This is history happening in real time. The indictment is filed. The clock is ticking. The 60-year exposure is real. This is the case of our lifetimes.